Charlie ought to go first, since you always have to wait for the bloviating lawyers to go before you speak.
Well, good evening, everybody.
Good evening.
I think this is a great way for y'all to send. That's all right. Oh, good. Good.
So we have Ron Carney, who was exonerated in New Mexico, Albert Burrell from Louisiana, and Shuja Graham from California.
We'll get some. We're going to be with them all week.
How are you? Good to see you.
Nice to meet you. Well, as I was saying, I think that this is a great way for y'all to spend your spring break. It's obviously can be a very productive endeavor to come down and learn more about the current issues. And I've always thought that there were three real issues that had consumed this country since its origination, and one of them was slavery and the race issue. The second issue was abortion and a woman's right to choose. And the third issue has always been capital punishment. And it seems like no matter how far we think we progress as a country, we keep fighting race issues. Some of the stuff that has been said about President Obama is as blatantly racist as anything that I've heard since I grew up in a small town in northeast Texas. And they used to have fountains, water fountains, and restrooms in the courthouse that said colored only or white only. And I used to, as a little boy, I used to go over there and drink out of the colored fountain to see if the water tasted different, you know? But that's still going on. And then I think that with the current Supreme Court, I think that the choice issue is still going on. And I think now the death penalty issue just continues to grow and grow and grow. And so I'm really glad that you're here, and I'm glad that you're participating in something that I think is important and productive. What I would like to talk to you about, well, let me go back to the end of the last call where the gentleman said, do you think that of the 100 and so people that were executed under George Bush, or the even more that have been executed under Governor Perry, were innocent? And I reviewed over 400 capital cases in the 8 years that I served as a judge on the Court of Criminal Appeals. And there was one case that always bothered me, and that was the case of a guy named Claude Howard Jones. And his case was kind of a nondescript capital case. It was the murder and robbery of a liquor store owner in a small town. And there was a snitch that identified Mr. Jones as being the one that went in the store and pulled the trigger and murdered the store owner. And in Texas, the testimony of a snitch has to be corroborated. It means there has to be something independent from the snitch's testimony that would tend to incriminate the person on trial and corroborate the snitch's testimony. And the only thing that they had to do that was a hair that was found in the liquor store. And they had a so-called expert that testified at the trial, and he said this hair is scientifically similar to the hair from Claude Howard Jones. And the court affirmed his conviction over my dissent, and I said that that was not enough. It was not scientifically reliable enough to believe that it would corroborate the testimony of anybody. And sure enough, Claude Howard Jones was later executed. And after his execution, the Innocence Project was able to secure independent testing, now DNA testing, of the hair. And it turned out that it was not the hair of Claude Howard Jones. And so that is the one that I think has probably been perhaps the most conclusively established, maybe not. There's always two ways you can argue all of these cases. When I was on we had about 400 of those cases when I was on the Court of Criminal Appeals. And when I left there as a result of what they called illness and fatigue. And that means that the voters were sick and tired of me. I lost my bid for re-election in 1998. And George Bush was re-elected governor on his political landslide, and all the Democrats were swept out of office. And it's been pretty much that way ever since. I was fortunate enough to serve on the 299th District Court, which is a felony district court here in Travis County, and I had two very, very important cases that I was allowed to participate in. One of them was I want to talk to you about, but actually I want to talk to you about both of them tonight. But the first one I want to talk to you about is Tim Cole, and then I'll end on the second one, which was the Cameron Todd Willingham case that we never really got finished in that court. There is how many of y'all are law students? Anybody want to be a law student, lawyer? Okay. There is an old video, it's not even on DVD, but there's an old video of a great show called Henry Fonda as Clarence Darrow, a one-man play. And it is exceptional. I commend it to all of you. If you want to be a lawyer, go get it and look at it and read it. But there's a statement there made by Clarence Darrow, who was just a really smart guy, intellectual guy, thinker. And his statement was, it is a shame to spend your life in an area, whatever the area is, but in an area that does not change and progress along with science and just the evolution of the normal flow of ideas and information. And he felt that way about the practice of law. And I felt that way about the practice of law, primarily as a judge in these two cases. The first case was the case of Tim Cole. Tim Cole was an African American from Fort Worth who had gone out to Texas Tech to go to school. And there was a series of rapes of young white co-eds on the Texas Tech campus by an African American male. And he would kidnap these women at knife point, and he would drive them out somewhere in some pasture in some field and sexually assault them, and then drive them back and release them. And they didn't know much about this fella except that he was a smoker. He was just smoked all the time. And Tim Cole, some way became, oh, I know what happened. They put a young, attractive Anglo peace officer, female peace officer, out on the Texas Tech campus, hoping that she would kind of be bait for the rapist. And as she's walking out of a pizza place one night, Tim Cole says hello and flirts with her. And as a result of this flirtation, he becomes a person of interest. He's done nothing wrong except flirt with a pretty girl. And they put his picture in a photo spread. And it is a highly suggestive photo spread. And they show it to a woman by the name of Michelle Mallon. And because of the suggestive nature of the photo spread, she identifies Tim Cole from the photo spread. And then, of course, she's now seen him in the photo spread, and so they have a live lineup. And Tim Cole is in that lineup. And of course, who does she pick out? The same person she saw in the photo spread. Mm-hmm. Not that she's identifying the rapist, she's identifying the person that she had previously identified. Mm-hmm. And then they go to trial, and all this time Tim Cole has protested his innocence, and so much so that the prosecutor in Lubbock offered him probation on this case. Okay. And he wouldn't take it because he was not guilty. In fact, when he went out there, he was in Fort Worth. His mother and I have become pretty good friends over this. He was in Fort Worth, and they go to the airport, DFW airport, to fly out to Lubbock, and they buy a round-trip ticket for his trial, so certain that he's going to come back after this trial because he has such faith in the criminal justice system. But sure enough, you know where this is going. They go to trial. And this woman, Michelle Mallon, picks him out in court, identifies him as the rapist. He's convicted and sentenced to prison for 25 years. During the course of all this investigation, in the Michelle Mallon rape, her car was used. The kidnapper, the rapist, used her car. As she was getting into it, he pushed her aside and he got in the car and drove her out and raped her. And he smoked all the way out there. There were cigarette butts left in the car that were never tested. There was a cigarette lighter left in the car, and it was never tested for fingerprints. And they ultimately discarded that. The Lubbock Police Department thought that it was insignificant.
Oh my God.
And the reason I keep talking about the smoking is because Tim Cole was an asthmatic and had never smoked a day in his life. And that was just fell on deaf ears to the jury. The jury convicted him and he went to prison. And he went to prison and was offered parole many times. And he said, I'm not going to get parole. I'm not going to accept parole because in order to accept it, you require me to confess my guilt and say that I'm guilty. I'm not going to admit to something that I did not do, number one. And number two is I'm not going to accept parole because if I'm out, I'd have to register as a sex offender, and I'm not a sex offender, and I'm not going to do that for the rest of my life. And so it turned out that he stayed in prison, and he had an asthmatic attack and died there. So he did not die on death row, but he died in prison. And the reason what happened was the fellow who raped Michelle Mallon was actually in prison at the same time Tim Cole was. And he was there for the offense of aggravated rape. And he was convicted out of Lubbock. And he was a smoker. And after the statute of limitations ran on the Tim Cole the Tim Cole rape, this fellow, his name was Johnson, wrote the district attorney and the judge and said, I'm the one that committed the Michelle Mallon rape, and Tim Cole, you've got the wrong guy in prison. Those officials never did anything in the world about that. Finally, Johnson wrote to Tim Cole's mother and found out, and she began pursuing this. And they did a DNA testing, and they conclusively exonerated Tim Cole in my court through the DNA testing and through the confession of the actual rapist. And that was actually my great honor to serve at that hearing and preside over that. But one of the reasons I bring that up is because what that brought into effect was how bad eyewitness identifications can be and how suggestive the practices can be. And the reason I passed out this handout is because it has this handout that I gave you. It talks about what is going on currently at the legislature. And these gentlemen testified in front of the legislature. And there is legislation up there now that would enact a statute that would require that eyewitness identifications be done in a certain way. And that is the progress that we are so hesitant to receive in the criminal justice system that I see now progressing along. But it just seems like it has been too long in coming when you have people like Tim Cole. This article says something that's very important, that says that of all the exonerations so far by DNA, DNA is only available in 5 to 10% of the cases. And the other cases are typically made with eyewitness identification, where there is no genetic material left behind, whatever the crime was, burglary, robbery, whatever it was, that would subject itself to genetic testing, DNA testing. And so that's why you have to have something like this to come along and improve the criminal justice system. But as we are so slow to accept the changes in science and technology and bring them in to make sure that the criminal justice system really does ensure fairness to everybody. And one thing that is very important in this case, in this article, if you have a chance to read it, is that everybody they talked to that testified before the legislature was convicted out of Dallas County. And you know what? You know why they're all testifying? Is because the district attorney in Dallas County had the courage to say, wait a minute, over all these past years, we might have convicted people that were not guilty, and we ought to have a conviction integrity unit and go back and recheck and double check all the evidence in those cases to make sure that's not happening. And so he's done that. We have just as many convictions, probably from our larger cities like San Antonio and Houston and Fort Worth. But the district attorneys and people there and Lubbock have been kind of stubborn and hard-headed about going in and reevaluating those cases, all right? And I think that the district attorney in Dallas ought to be applauded for doing what he's done as far as opening up the criminal justice system to say that we're not foolproof, that we are all human, we all make mistakes regardless of the good faith efforts. Now, let me do I have some more time or am I?
Yeah, sure.
Okay. That gets me to the Willingham case. And Willingham was convicted of a terrible, terrible crime. A few days before Christmas, in 1991, Willingham was living in what we used to call in East Texas the shotgun house. And it was just an old wood frame house that was probably built so long ago that it didn't have electricity. And it might not have even had indoor plumbing at the time that it was built. But over the years, as electricity came into being, they would wire it. And as indoor plumbing came more prominent, they would put in bathrooms and that type of stuff. Anyway, he was living in that type of house and a few days before Christmas. And at 9 o'clock on the morning, I believe, of December the 23rd, 1991, his house caught on fire. His wife was gone. He was able to get out of the house, and his 3 babies, 3 little girls, 1 girl and then 2 twin girls, were all died in the house fire. And immediately the attention focused on Willingham, who by all accounts was not the nicest guy in town. Okay, and he had lots of kind of minor run-ins with the law and his domestic disputes with his wife and that type of stuff. But anyway, they focused on him and they relied upon the Navarro County Fire Marshal and the Texas Fire Marshal to come in and investigate this scene to see if it was arson. And sure enough, they relied upon the science effective in 1991, and they applied all the state of the art in 1991, and they determined that this was arson. And they presented their case to the district attorney. The district attorney presented that evidence to the grand jury, and the grand jury indicted Willingham for the offense of capital murder. They appointed him a lawyer. The lawyer went out and hired his own expert. And his expert reviewed everything, and he said, according to the state of the art, right now, in 1991, this was an arson case. There's evidence here of arson. And so, it's not surprising then, in my mind, that Willingham was convicted of the offense of capital murder. And it is very unremarkable that he was given the death penalty, because it's a heinous, terrible thing for a man who would burn up and kill 3 children. So he was placed on death row. Well, all that is well and good, except from 1991 up until 2004, his execution. The art of fire science changed from an art to a science. And there were significant, major developments in arson science over those years, to the extent that they were so major that they said what we were relying on in 1991 was bunk. It was old wives' tale. It was witchcraft. It was just stuff that nobody in their right mind would rely upon today. In fact, in 2004, one of the foremost people in the area of arson science examined all the evidence again. And he looked at it and he said, there's no proof here of arson whatsoever. That as a society that is going to evolve and develop new things like DNA, we're going to have those developments in every area of science. DNA, arson science, ballistics, eyewitness identification, everything you can think of, that the legal system has got to figure out some way to adopt and embrace those changes. And when there has been a significant change, to go back and look at the convictions that relied upon what is now, every expert in the world will tell you, was junk science. But the problem is, with the legal system is, we don't do that. In fact, when we tried to have the hearing in Willingham, I invited Governor Perry, I invited the state prosecuting attorney, and I invited the Navarro County District Attorney, his office, to come down and present any evidence that they wanted to. Just like y'all are going to testify Wednesday. And I said you could present evidence for, against, or on any issue in this case. Come on down and we'll hear you. None of them showed up except the Navarro County prosecutor. And you know what he said? He said, Judge Baird, you're not fair for holding this hearing. You're not the one that ought to be having this hearing because you received a death penalty from the Texas Coalition to, excuse me, you received an award from the Texas Coalition to abolish the death penalty. You're biased against capital punishment, and therefore you have a bias in conducting this hearing. And I said, I won't tell you what I said, but we went ahead and we had the hearing. And by the time the hearing was over, he had gone to the Third Court of Appeals and successfully got an injunction essentially against me from proceeding with that hearing any further. And that's where it stands right now. And so I guess I'm disappointed that we didn't get a chance to resolve that case. But I'm disappointed that so often the people that are sworn to take an oath to seek justice and to not seek just convictions but to seek justice are oftentimes the ones that are working harder and harder than anybody else to thwart the truth and to see that justice has in fact been done. And I'll close on this. You would think that if there was ever a dispute or an issue raised about the state of Texas executing an innocent person, that everybody, every Texan ought to be forthcoming and say, you know, what we ought to do is just hold the phone and at least in this one particular case and see if we got it right. Because obviously the problem with capital punishment is that you cannot undo an execution, obviously, once it's occurred. It's not like, you know, you can set somebody free years and years after prison like these people with eyewitness identification cases that are here. Anyway, those issues are out there. I commend you again for being here. I appreciate you giving me a few minutes to say those things, and thank you very much for having me.